He looked at me the way a prepared man looks at a room he believes he has already solved. That is how I would describe it. Not hostile, not afraid. The specific ease of someone who has done the work, organized the materials, tabbed the folder, and who is waiting for the room to recognize what he has done. I have watched that look on attorneys with the goods. I had never quite seen it on a man who had come to tell me that I did not have authority over him. He had a 12-page filing, hand-printed, color-tabbed. He had prepared it to explain that the name on the complaint, his name in capital letters, was not him. It was a fictional government entity, and he, the living man, was not subject to this court. He was confident. He had clearly said this before, in smaller rooms, to people who did not have the authority to answer him. My name is Marcus Reed. I was a circuit court judge for 28 years, and what I carried out of that room was not the folder. He left with the folder. If you have ever watched someone invest real preparation in exactly the wrong argument, subscribe, hit the bell. What I bring to this channel required 4 decades to earn, and it is yours. And whatever this case brought up for you, whatever came to the surface while you were listening, the comments are the place to set it down. I read every one. What comes next is not easy to hear, but the record requires it. Before he said a single word in that courtroom, he had already handed me everything I needed. A 12-page hand-printed filing, his own words, his own theory, his own belief about why none of what was about to happen in that room applied to him. I had read it the night before. I had set it down on my desk at home, and I had sat with it for a few minutes. Not because it was complicated, but because I wanted to understand what kind of person walks into a courtroom with a theory like this one and genuinely believes, that the room is going to receive it. I have been in that seat for 28 years. I have seen a great many things brought before me as argument. I have seen desperate arguments and dishonest arguments, and arguments that were technically elegant and morally bankrupt. I have seen people argue that the law did not say what it plainly said. I have seen people argue that the evidence did not show what it plainly showed. What I had not seen very often, and what I want to tell you about today, was a man who had decided that he was not the person the law was talking about. Not because he was innocent, because he had found a theory, because he had read something somewhere, and he had decided that it was the key to the room he was about to walk into. And that room, my room, was going to open for him the way it had never opened for anyone who came before him. He arrived early. I want to start there because it matters. He arrived before his scheduled time, and when the bailiff noted his presence in the anteroom, I was told that he had a folder with him, a thick folder, color-tabbed. I learned this the way I learned many things about defendants before proceedings began, from the people in that building who pay attention to the things that happen before the session is called to order. Color-tabbed. That detail stayed with me before I ever saw the man himself. When he entered that courtroom, he entered it the way people enter rooms they have already decided belong to them. Not aggressive, not loud, something quieter than that, and in some ways more telling, the ease of a person who has not considered the possibility that this room might have a different opinion of him than he has of himself. He set the folder on the table. He arranged his materials. He sat down and he looked at me. And I want to describe that look precisely because it is important to what follows. It was not a look of hostility. It was not a look of fear. It was the look of a man who is prepared, who believes that preparation is the difference between winning and losing, and who has done his preparation and who is ready. I have seen that look on attorneys who had the goods. I had never quite seen it on a man who had arrived without counsel to tell me that he was not subject to my jurisdiction. On the other side of that room, there was a woman. She had been waiting on the resolution of this dispute for 3 years. 3 years, not waiting passively, actively navigating a process that this man had made harder at every available opportunity. She had filed the responses his filings required. She had arranged her own documentation. She had arrived prepared in the way that people arrive prepared when they are not in possession of a theory, when they are simply in possession of the facts and a belief that the facts will be enough. She had been waiting for this room for a long time, and when she sat down and looked at the same man I was looking at, her face carried the particular stillness of someone who has already spent more energy than this situation deserved and has decided not to spend one more unit than is absolutely necessary. I want to tell you what I thought, looking at both of them. I thought, one of these people came here to resolve something. One of these people came here to avoid something. And the difference between those two purposes was going to be visible inside of 30 minutes. I had seen versions of this theory before, not often, but enough. The Strawman doctrine, the belief that your legal name, rendered in capital letters on official documents, represents a fictional government-created entity distinct from your living self, and that this fictional entity, not you, is the subject of any legal proceeding, is not a new argument. It circulates. It finds people who are looking for it, usually people who are already in some form of conflict with an institution and who would prefer that the conflict exist on terms they can control. I understand the appeal. I want to say that clearly because I think it is important not to dismiss what this man believed as pure stupidity, because it was not stupidity. It was something more complicated. It was a conviction. And conviction, as I have said before, is harder to address than confusion, because confusion remains open to information, and conviction has already decided what the information means. He had done research. That color tab folder was not assembled in a night. He had printed case citations, some real, some distorted past recognition, some entirely fabricated, which is a thing that happens in these filings more often than most people realize. He had highlighted sections of what appeared to be legal text. He had prepared a written statement of position that ran to 7 pages before the exhibits began. Whatever else I thought about this man's choices, I could not say he had not worked. He had worked. He had invested real time in this. And sitting in that seat, reading what he had prepared, I felt something I did not entirely expect to feel, something close to sadness, the specific sadness of a teacher. And I do not use that word lightly, because a bench is a kind of teaching. Watching a student who is clearly capable of real thought have deployed that capability entirely in the wrong direction. The question I kept returning to, reading that filing the night before, was not whether his theory was correct. It was not. The question was, what has to be true about a person's life for this theory to feel like a solution? When the session was called to order, he did not wait for me to speak first in the way that proceedings conventionally begin. He made a declaration. He announced, and I'm going to give you the substance of it as precisely as I can, because precision matters here, that the defendant named in this proceeding was not him, that the name appearing in capital letters on the complaint was a legal fiction created at his birth by the government, a corporate entity existing in maritime admiralty law, and that he, the living man, was a sovereign individual, not subject to the jurisdiction of this court. He said this with the calm of someone reading a prepared statement, which is exactly what he was doing. He had the folder open. He had notes. I let him finish. I want to be clear about that choice, because it was a choice. I could have interrupted him at any of several points where the appropriate procedural response was available to me. I did not. Not because I was unsure of what to say, because I have found over 28 years that a man who has prepared an argument deserves to have it heard completely before it is addressed completely. There is a respect in that, not for the argument itself, but for the person who made it. And there is also a practical dimension. A man who is allowed to say everything he prepared will sometimes, in the saying of it, say something he had not intended to say. He finished. He looked at me. I want to tell you what I said and why I said it the way I said it. I did not address the theory, not yet. I asked him a question, a simple, procedural, specific question about the underlying dispute, about the transaction at the center of the complaint, about the date of it, about his understanding of the terms at the time, a question that had nothing to do with maritime admiralty law and everything to do with what actually happened between him and the woman sitting across that room from him. He paused, and in that pause, which lasted perhaps 4 seconds, which is a long time in a courtroom, I watched something happen in him that I have watched happen in many defendants over many years, and that never looks exactly the same way twice, but always means the same thing. He was recalibrating. He had prepared for one kind of conversation. I was having a different one. And the question before him, in that 4 seconds, was whether to insist on the conversation he had prepared for, or to answer the question I had actually asked. He answered the question, not completely, not without several subordinate clauses that attempted to route the answer back toward his jurisdictional argument. But he answered it. He acknowledged the transaction. He acknowledged the date. He did not acknowledge the terms as the plaintiff remembered them, but that was a separate matter. The point was that he had, in answering a direct question about the facts of the underlying case, stepped inside a proceeding he had spent 12 pages arguing he was not subject to. I noted that for the record. Precisely, without editorial. The record is not the place for editorial. It is the place for precision, and precision was serving me well. What followed over the next 40 minutes was one of the more unusual procedural passages I have presided over. And I do not say that to suggest it was dramatic in any way that looked dramatic from the outside. It was not. What it was methodical. He would return periodically to the jurisdictional argument. I would return each time to the facts of the underlying case. He would cite an authority I had not previously encountered in this context. I would note the citation and return to the question at hand. He was, I came to understand, less interested in winning the jurisdictional argument than in being on record as having made it, as if the record of the argument itself was the point. I have thought about this since. What does it mean to make an argument you do not expect to win, in a room that was not going to receive it, at considerable personal cost in time and preparation. I think it means the argument is not really about the room. It is about something the person needs to believe about themselves, about their relationship to the systems that govern their life, about whether those systems have legitimate authority, about whether the fact that they disagree with an outcome means the outcome can be contested at the level of the room's right to produce it. What I could not give him, and what no bench can give any person, is a validation of that belief. The room is the room. The law is the law. His disagreement with an outcome did not reach back in time and change the terms of the transaction that produced the outcome. And when I told him this, directly, clearly, without any of the diplomatic softening that can sometimes obscure the actual meaning of what is being communicated, I watched something in him shift, not break. I want to be precise about this. A man who has committed himself this fully to a framework does not abandon it in a single session. What shifted was something more specific, the certainty, the specific quality of certainty with which he had walked into that room, the ease I described earlier, the sense of a prepared man entering a room he believes he has already understood. That quality was no longer fully present. He was still in the argument, but he was in it differently than he had been when he arrived. The woman on the other side of that room had not moved. She had not reacted, not visibly, to any of what had taken place in the previous 40 minutes. I noticed this. I noticed most things from that seat, and one of the things I notice is who in the room is performing and who in the room is simply present. She was simply present. She had her own folder, considerably thinner than his, organized in a way that suggested she had not needed many pages to say what she had to say. She had been in this dispute for 3 years. She had filed her responses. She had done what was required. And now she was here, at the end of that 3-year road, watching a man with a color tab folder explain to a federal judge why the judge's room did not apply to him. What she needed from me was not complicated. She needed someone with the authority to say, yes, this happened. Yes, the obligation exists. Yes, the resolution is what the record shows it should be. She had been waiting for that sentence for 3 years. I was about to give it to her. I had one more exchange with the defendant before I ruled. I asked him, and I'm going to tell you exactly how I phrased this because the phrasing was deliberate. I asked him whether he was prepared to address the merits of the underlying claim, not the jurisdiction, the claim. He said he maintained his position that the court lacked jurisdiction over his living person. I said, I understand your position. The court's position is different. Are you prepared to address the merits? He was not. And in declining to address the merits, he left the record with the only version of events it was going to receive, the plaintiff's version, supported by the documentation she had brought, supported by the correspondence she had preserved, supported by the timeline she had constructed over 3 years of waiting for exactly this moment. He had not prepared for the record. He had prepared for the theory. And the record was what this room ran on. There was one outcome this record could produce. I produced it. I found for the plaintiff. I held that this court had full jurisdiction over the proceeding and over the defendant, whatever name he preferred to use. The man sitting in that room before me was the man named in the complaint and was bound by the same law that bound everyone else who entered this building. The obligation was real. The evidence was real. The ruling was the only thing the record could have produced, and I produced it without ceremony and without delay. I want to tell you about the moment after the ruling. He did not rage. He did not make a scene. He sat very still for a moment, and I watched that stillness, because stillness in a defendant after a ruling contains information if you know what you're looking at. This stillness was not acceptance. It was not relief. It was the stillness of a man who is deciding in real time what the ruling means for a framework he has spent considerable effort constructing. He was trying to locate the ruling within the theory. He was trying to find a place where the theory could absorb what had just happened and remain intact. I do not know if he found it. That is not my business. My business was the record, and the record was complete. What I have thought about many times since, and I do want to tell you this because it is a thing about this case that has stayed with me most specifically, is the folder. He left with the folder, the color tab folder, the 12-page filing, the exhibits, the highlighted citations. He gathered them carefully in the way that people gather things they are not yet ready to let go of. And he walked out of that courtroom carrying them. I filed my ruling. That is what I did with my conclusion. There is something I want to say directly, and I am going to say it without softening it, because softening it would make it less true. A theory about why the rules do not apply to you is not a defense. It is a description of a belief. It is a statement of position. This room, any courtroom, in any jurisdiction, is not in the business of validating beliefs. It is in the business of applying the record to the law and producing an outcome. That is the only business a courtroom conducts. And the man who walks in with a theory that the room's business does not reach him is the man who, in the words I have used before and will use again, has prepared the wrong argument for the right room. The woman who sat across from him had not invented a theory. She had a record. She had documentation of what was owed and when and by whom. She had been patient in the way that people are patient when they believe the process will eventually produce what it is designed to produce. 3 years is a long time to be patient. 3 years is a long time to carry something into every day of your life without resolution. The unfinished business of an obligation someone refuses to meet. The weight of a wrong that sits there waiting for a room that has the authority to name it. She had carried that for 3 years. And when I ruled, I thought about that. Not performatively, not as a theatrical gesture in the direction of her endurance. I thought about it because it is the truth of what courts are for, not philosophy, not theory. The person who has been wronged and has brought the record of the wrong to the room that can address it. That is what courts are for. That is what happened in that room. Now I want to speak directly to you. There is something this case asks of everyone who hears it, and it is not about the law. It is about a habit of mind that is considerably more widespread than the Strawman doctrine, and that does not require 12-page filing to act on. The belief that the rules apply to everyone else. It is one of the most durable beliefs I have encountered in 39 years. It lives in boardrooms, and it lives in courtrooms, and it lives in the ordinary daily life of anyone who has watched someone in a position of comfort or power or simple stubbornness decide that the obligation in front of them does not reach them. Sometimes it wears the costume of a legal theory. More often it wears nothing at all. It is just a quiet assumption, acted on daily, that the framework everyone else operates within does not apply with equal force to them. The concrete thing I want to leave you with is this. The next time you encounter that belief, in a room, in a conversation, in a situation where someone you know or work with or live alongside is operating on the assumption that they are the exception to a rule that everyone else has to follow, I want you to notice it, not confront it necessarily, just see it for what it is. Call it what it is, even if only to yourself. Because a belief that goes unnamed continues to operate as if it is simply the way things are, and the way things are is very rarely the way things have to be. I have spent my career in the room that is specifically designed to say no, actually. The rules apply here, all of them, to everyone who walks through that door. And the satisfaction of that room, and there is a satisfaction, even after 39 years, even in a case like this one where the outcome was never genuinely in doubt, is the satisfaction of a place that does not negotiate the terms of its own authority. I want to hear from you. I want to know if you have ever been in a room, any room, a workplace, a family situation, a neighborhood dispute, any human context where someone used a framework of their own invention to avoid an obligation they simply did not want to meet, where they constructed a reason, elaborate or simple, for why the rules that governed everyone else did not govern them. I want to know what that looked like. And I want to know what happened when the room did not go along with it. Write it in the comments. I read every one. If what you heard today felt like something you have been waiting to hear said out loud, the account from inside the room, without the ceremony, without the diplomatic softening, I would be glad to have you here. Subscribe. Hit the bell. What I bring to this channel is what I brought to that bench for 28 years. The record as it was, the ruling as it had to be, and the truth of what it looked like from the seat that decided. He had the folder. He had the tabs. He had the theory. The room had the record. I am the one who went home that night with nothing left to carry.